Okay, thanks again for everyone for being here today. And also my thanks to Kristen Wolski, Josh Sylvie, and Susanna Cleveland for all of their support and ideas in getting this series started. This is our first rodeo with doing a series like this, so please forgive any technical difficulties. We're glad you're all here. And again, to start, we'll be talking initially about, because that's quite recent and also quite useful for music librarians and music library users. So again, a lot of you probably know me. I'm the Music Special Collections librarian here at UNT. And my interest in copyright comes from several different angles. First, as a performing musician, I'm interested in my rights and responsibilities in performing copyrighted material. And if I ever come up with anything that's cool enough to steal, I want to know my rights too. As a librarian, I receive scan requests for published and unpublished special collections items, and I help users determine if a work is in copyright. And I also help them to track down rights holders for permission. In addition, I work extensively with the preservation of different types of materials, and copyright law gives libraries and archives latitude for those activities. So let's start this legal discussion with some legal boilerplate. I'm not an attorney, and I don't play one on TV or in the library. So none of this should be construed as legal advice, but rather information. And clearly, it's in our best interest to be well informed as participants on many levels of musical culture, and to know our rights as well as our responsibilities. In order to focus on the Music Modernization Act, we'd like to refer those in need of background information to UNT's Copyright Quick Reference Guide, which is an extensive source organized for ready access to specific topics. Still though, a little context is useful. While the basic notion of copyright is enshrined in Article 1, Section 8, Clause 8 of the Constitution of the United States, copyright law is subject to changes that reflect evolving economic, social, and technological realities. These changes are addressed by legislation, but interpreted and shaped by the courts as the letter of the law makes contact with vigorous and consequential real-life disputes. So how much have things changed? The Copyright Act of 1790 provided for a copyright term of 14 years with a 14-year renewal. Obviously, sound recordings weren't a thing at this point, nor were photocopiers and scanners, to say nothing of the internet, digital preservation, and born digital documents. So the latest in a long string of legislation passed to address this changing landscape was the Music Modernization Act of 2018. The Music Modernization Act, or MMA, is organized into three areas. Title I is the Music Licensing Modernization Act. Title II, the Classics Protection and Access Act. And Title III is the Allocation for Music Producers Act. According to the US Copyright Office, Title I replaces the existing song-by-song compulsory licensing structure for making and distributing musical works with a blanket licensing system for digital music providers to make and distribute digital phonorecord deliveries. It also establishes a mechanical licensing collective to administer the blanket license and a digital licensee coordinator to coordinate the activities of the licensees. So centralizing a lot of things that were scattered activities before. On July 8th of last year, 2019, the Copyright Office named an entity conveniently known as the MLC to serve as the MLC. And you can read more about them at their website, linked there on the PowerPoint slide. For the moment, I'm going to briefly skip to Title III, which allows music producers, mixers, or sound engineers to receive royalties collected for the uses of sound recordings under the Section 114 statutory license by codifying a process wherein the designated collective, which is Sound Exchange, will distribute those royalties to such parties under a letter of direction. Lots of legalese, but you can read more about the Sound Exchange as well at their website. Now, several useful developments came along with Title II, the Classics Protection and Access Act. In particular, it brings pre-1972 recordings partially into the federal copyright system, out from under a patchwork of often contradictory state laws. As listeners, collectors, researchers, and performers of the contents of these recordings, we can also celebrate these recordings now also have a specific path into the public domain. And indeed, the print rules you may be familiar with don't cover sound recordings, so this needed to be legislated. You can see the detailed stages on the slide here, but all of this is to say I intend to throw a pre-1972 public domain record party on February 16th, 2067. In addition, the Classics and Protection Access Act also establishes a process for lawfully engaging in non-commercial uses of pre-1972 sound recordings that are not being commercially exploited. A final rule on how exactly one goes about that was just issued in April of 2019. That's available on the Copyright Office website if you Google Music Modernization Act. The gears in your mind might already be turning as you see the opportunities these changes open up. As the Association of Research Libraries has noted, copying, quoting, and generally reusing existing cultural and scientific material can be a critically important part of generating new research and culture and promoting intellectual exchange. So having a clearer path to use these cultural materials without fear of litigation or without a protracted and uncertain permissions process facilitates new works, balancing what the ARL calls the social bargain of copyright law, to both protect and encourage creativity and innovation. For more clarity on what goes into the public domain when, the Cornell University Copyright Information Center offers a detailed resource on the public domain status of both print works and sound recordings for both published and unpublished materials. And of course, the Music Library Association maintains a collection of resources on copyright grouped by topic. Now also today, we'd like to address some frequently asked questions. The first one is, when I wanted to use a recording of a piece that was in the public domain for my project, I was told it was still under copyright. How can that be? The heart of the matter here is, of course, the difference between copyright for print materials and sound recordings, as we've addressed in our earlier discussion. But for the sake of thoroughness, I would also look at the basic assumption that the source of the work is in the public domain. And that can be verified through a resource like the Cornell page we just looked at. For that matter, if you're working from a published print edition of the work, say a standard notation edition published in 1986, that's an editorial interpretation of lute tablature from 1687, that edition is under copyright. But even then, even if source material for the recorded performance is in the public domain, even if the performer read it directly from the Baroque lute tablature from hundreds of years ago, the sound recording is a different ballgame. Now, thanks to the Music Modernization Act, if it is a pre-1972 sound recording, we know when it will be in the public domain, but that won't help us for a while yet. As noted earlier, there is also a process for pursuing non-commercial use for pre-1972 recordings. But for the time being, the fact remains that those are still under copyright, because even though the piece was put down on paper hundreds of years ago, the fixation of this individual performer's expression of the work in a sound recording was done in a time and place that protects the performer's exclusive rights to their unique interpretation of the work. So just as a concrete example, going back to our Baroque lute tablature, you can't use a Julian Bream record without permission just because the work he's performing is older than George Washington. Another frequently asked question is, why do I have to ask for permission to use a song as a sample, even though the sample is really short? Now again, there's more than one way to interpret sample, but let's suppose we mean an audio excerpt reused in a new work. This is a lively area of copyright litigation, with some famous examples, like Vanilla Ice's use of the bass lick from Under Pressure in Ice Ice Baby, which was ultimately settled out of court. Here, we assume that the copyright status of the sampled material as a sound recording is not in dispute. Then, a logical question is whether fair use applies or ought to apply. Contrary to what you may have heard, fair use isn't tethered to a set percentage where, for instance, 9% is okay, but 10% is not. Instead, fair use depends on the weighing of 4 factors: the nature of the work, the nature of the use, the amount and substantiality of the use, and the impact on the market. The one that especially catches my eye among the 4 factors for sampling is the amount and substantiality, particularly the substantiality. You choose a sample of a sound recording because there's something ear-catching to it, something substantial and creative. Small excerpts can be essential elements of an original creative work, even if the reuse is creative and transformative of its original purpose. This is why movie reviews on TV use nondescript footage, and not, for example, the climactic moment where you find out Darth Vader is Luke's father. Hopefully everyone knew that. And in the case of Ice Ice Baby, a whole generation hears that bass figure and says, hey, Vanilla Ice, and not, hey, David Bowie and Queen. So just that tiny excerpt was highly substantial, and now it's stuck in my head. So those are two questions that are frequently asked or related ones. And so with that, I'd like to open the floor to our next presenter. So I'll stop sharing my screen and turn things over to Rebecca.
Hi. I don't have a screen share. I'm just going to talk to everyone. So I hope that's okay. I was really excited to be invited to do this because my book project is actually about professional musicians and property in the French Revolution. And the reason I got really interested in this is because I realized how fundamental the issue of property was to the constitution of professional musicianship as we know it in a modern sense. And so I want to take us all the way back to the 1710 statute of Queen Anne, that Maristella referred to, because that really is considered the kind of foundational copyright legislation in the West, in modernity. But the fact was it only protected authors and publishers, and really it only protected publishers, because what it did is it granted privileges for printing books. And so a privilege is different from copyright. And we have to be really careful about equating the two too closely, because a privilege meant you could do something at the exclusion of everyone else. And so a privilege wasn't guaranteed. You had to request it, usually from a monarch. It was revocable, so the monarch could technically take it back at any time if they wanted to. They could be renewed for reprints, and they could also be renewed by heirs. And so, for example, Francois Couperin's family kept renewing the privileges that he had to his musical works over the course of the 18th century, and so they kept making money off of them. And finally, privileges didn't extend across political borders. And so that meant that as soon as you printed a piece of music, let's say in Leipzig, someone in Paris could immediately pawn it off and sell it there. And you had absolutely no recourse because these privileges were not harmonized across political boundaries. So the statute of Queen Anne did not originally apply to music, but over the course of the 18th century, composers started to try to use that statute in order to protect their musical works. And so some of the more famous cases for that involved J.C. Bach and also his associate Abel. And so there are basically two interpretations for how and why composers went about trying to protect their work. One of them is an intellectualist interpretation, and one is a materialist interpretation. So the intellectualist interpretation is essentially that composers wanted to protect their self-expression as a kind of property because it was something that was personal to them and that it was articulated something new in the world. The materialist interpretation is basically that printing privileges and court patronage and performances were not as lucrative as they used to be. And so composers were trying to get a bit more action, essentially just to make more money off of legally protecting their work. And so the reason that the French Revolution is really crucial to this story is that it abruptly abolished privilege. So in most textbooks, we read about it as the abolition of feudalism, but it was an abolition of privilege. And there were all kinds of privilege, right? Some people owned the privilege to dictate when you could play the violin in the street in little towns in provincial France. I mean, privileges extended far and wide in the music world. And so when privilege was abolished, a new regime was set in place that was essentially a modern property regime. And there are historians, many historians agree that that's really the defining legacy of the French Revolution. And what it meant was modern property was essentially coterminous with the emergence of early capitalism. And so you had this need to strictly delineate public from private property as part of that new economic system. And so this is where we get the conundrum of knowledge and cultural products under capitalism. Because as Maristella said, we need knowledge to circulate in order to inspire new knowledge, right? And we need cultural products to circulate so that people can feel part of their culture and have access to cultural products that make them feel part of a particular identity, right? But you need to incentivize artists. You can't just say that all of us are putting our music out there for just to make everybody feel good, and yet we have nothing to eat. And this is an exact complaint that composers started making during the French Revolution. And so you had composers and music publishers trying to argue that music was a private property, basically because they wanted to make proceeds off of it. They wanted to be able to protect it so they could make money from it. But you also had the nation, in this case, the French nation, saying, this is public property. This is our cultural heritage. This is a national industry that we make money from with musical instrument building and with publishing and printing. This belongs to the nation. And so in 1793, the Declaration of Rights of Genius was passed. And this was really the first copyright law that explicitly protected music. And that use of the word genius is important because it meant that really a defining criterion for protection was originality, right? So the idea of genius had kind of transformed into an understanding of someone putting something original into the world. And the Declaration had some caveats. And basically the compromise between private and public property was that a composer, in the case of music, had rights to their work unless they sold them, or upon their death, it would be inherited by their heirs only for a set number of years. And then it would go into the public domain. And so there were some questions that were left lingering by that particular legislation. And they're questions that in many ways we still deal with today. And so Maristella made that comment that they didn't have the internet then, they weren't sharing on Spotify, they didn't have YouTube. And that's all true, but there were musical genres that were essentially meant to circulate music that couldn't circulate on its own. So for example, there were arrangements of operas, there were arrangements of symphonies, there were theme and variation sets where people would take a theme from a famous opera and set it for the piano so that you could sit and play it for yourself at home. This is essentially an early kind of recording technology. And these kinds of genres were left in question by that legislation. And so it's something that really had to be left to be figured out by trial and error over the course of the 19th century. And it's, I'm fascinated by some of the debates that Maristella mentioned, because they're ones that had already come up when this legislation was passed. And it was essentially codified into law from the very beginning, the tension between a composer's rights over their music and the public. And that's not even to mention performers, because performers are making arguments that their performances of music were actually a kind of intellectual property that deserved protection as well. And that's a much more complicated story than I have time to tell. So I'll just suggest to you, there is actually a graphic, it's not a graphic novel because it's not a novel, it's almost like a textbook. It's called Theft, A History of Music. And it's sold, it was created by the Center for the Study of the Public Domain at Duke Law. And so if you want a very fun trip through music copyright and music as intellectual property, I highly suggest this. So with that, I'll turn things over to the next panelist. And if anyone wants to ask me questions later in the program, I'd be happy to answer them. Thanks, everybody.
Well, good afternoon, everyone. My name is Kevin Hawkins. I'm in the UNT Libraries with Maristella. Along with my colleague Yvonne Dooley, I am one of our copyright specialists who provides guidance, but not legal advice, to members of the UNT community about copyright as it relates to their personal and creative works. So we maintain that quick reference guide that Maristella referred to earlier. She gave us a helpful introduction, or not introduction, but sort of overview of the MMA, one of the sort of really the most recent copyright legislation in the US. And I wanted to talk about another kind of recent development relating to the practice and use of copyright protected works in the US. It's not law, but it is very timely. And it relates to fair use and the current kind of pandemic situation. So Maristella, of course, talked a bit about fair use. This is broad category of defenses to copy against an accusation of copyright infringement, meaning these are certain uses that are considered fair that you can make of a copyright protected work without needing to get the permission of the rights holder. And she cited the portion of the law that talks about these broad categories, broad abstract terms. And this is all, a very important part of the way that creators work, right? We do things like borrow samples from other works. But as scholars, it's really especially important because we often need to quote from other work or include samples or reproduce works in their entirety, like a picture of a piece of artwork, right? And this can raise all sorts of questions about in which cases we need to get permission from a rights holder to do so, and in which cases you can do it without permission because the use is fair. And so the recent developments I want to talk about here again kind of relate to the current pandemic. I mean, so these are not just uses that individual scholars and artists make, but some of fair use also provides the basis for the activities of libraries. Libraries, for example, rely on fair use in large part as the basis for services like online document delivery, whereby we deliver a digital version of like a book chapter or journal article that a user requests. And for our online course reserve services, where we, again, make digital versions of book chapters or individual journal articles available to students who are currently enrolled in a course. So fair use, this doctrine of U.S. copyright law provides the basis for these services here. But during the current pandemic, many libraries have loosened their rules on the maximum amount that they will make available through online course reserves. I'm going to share my screen because I have one slide to show you here. I have put on here the title of this document and a tiny URL that you get to it if you're interested in reading more about it. So this is a statement that a number of copyright specialists, people like me in equivalent positions at other institutions, have put together, in which we talked about the way that fair use is implicated in the sort of current situation here, and have provided a sort of justification for libraries, again, kind of loosening the rules here on the maximum amount that we'll make available through things like online course reserves. Right, so these libraries are maybe digitizing more than a single chapter or journal article, perhaps even an entire work that was planned to be used in a face-to-face classroom setting, and then making these works available to the same people who would have been in those classrooms, right? The students who are currently enrolled in that course. So in this document, it talks a bit about the 4 factors of fair use and how it all relates to the current situation. And why there's a sort of clear basis for making these changes, sort of temporary changes to our approaches to our regular operating policies. So I'll really stop there, but looking forward to the discussion we have after all the initial panel presentations.
I guess I'm next. John Murphy here. I'm going to address 3 of the frequently asked questions I received from the library, and then add 3 quick thoughts of my own. I'm going to share a document. First one concerns students performing from scores that were obtained for free on the web. So I assumed that was referring to International Music Score Library Project scores. I found a review of this website in JAMS and an article by the man who runs it in another journal. The This archive is based in Canada. They take steps to ensure that everything they offer is in the public domain. They leave it up to the user to check whether scores can be used without risk of copyright infringement. And my thought about that is that something, strictly speaking, may be in the public domain, but it's worth pausing to think about what would happen to the total set of scores that are available to us if everyone did that, if no one bought music ever again. It's related to the question of what if no one wants to pay for music ever again? So I think there are two levels of this at least. One is what is strictly required and legal. The other, what is best for creators and users of music. So perhaps we can come back to that in the discussion. Second question, does copyright mean that bands can't cover songs publicly? No. It's up to the venue that offers live music, that hires a band. Hopefully they hire a band. That's why you see ASCAP, BMI stickers on the front door. They have to pay. And that's a blanket license that covers all of the copyrighted music that presumably is going to be played in that venue along with the original music. A couple of links here. I'll share this document afterwards. This I interpreted as directed towards jazz interpretations of copyrighted tunes. So in jazz, we don't really talk about covers because there are so many versions of the tunes that we play. It's only in rare cases where one specific version is considered the original. We don't really use that term. So copyright attaches to the melody, and even a very recent, about to be released album has a version of someone else's tune, and presumably that had to be licensed. So it's released as, it's called Ugly Beauty on the track list, and it is Monk's Ugly Beauty. It's just in Kurt Rosenwinkel's version with his improvisation. So jazz performers who want to do that with copyrighted music must take care of the licensing, and Maristella pointed you in the direction of the mechanical licensing. So to get around that, it's traditional to use the chord changes, but not the melody, in which case you don't have to pay licensing. You just write a new melody on the existing chord changes. 3 quick thoughts at the end. It's a small world, and rather than relying on what's strictly legal, I recommend to my students that they create relationships with content creators based on mutual respect, and do things like ask permission to use a syllabus assignment, to use a transcription by a performer who's reachable and someone you can ask about. Our graduates have run into the automatic copyright policing that happens on the major platforms. We had an alumnus who wanted to do a jazz listening party over Facebook Live, and the algorithm kicked in, prevented him from doing that, so he's doing it on Zoom. The third thing I learned when I created a class to be offered completely online is that many of the things that professors routinely do for the classroom with audio, such as making our own local copy of the audio in order to do clever things with it, like add textual labels or do sound analysis using Sonic Visualizer, or map the measures with transcribe and label the events for transcription. That might be okay in the classroom if we're just projecting it to all the students at once. But when I saved that as a file and put it on Canvas, I was advised by the former library's copyright lawyer, Stephen, that I could not do that because creating that local audio file was a violation of copyright, even though I was adding transformative information to it in the form of my listening guide. It wasn't enough to overcome the copyright violation and the added complication of if it was a track that I needed to make a local copy of from a streaming source, then fixing that stream in an audio file for the purposes of making an educational resource violated the terms of service of the streaming service, so that was illegal. So as Kevin said, in the context of pandemic and more online teaching, more and more instructors are going to be facing issues like this, where something that was unproblematic or considered unproblematic in the classroom suddenly becomes a problem when it's done online. So I'll stop there and look forward to our discussion.
All right, thanks to all of our presenters. It's been great to get such a wide range of perspectives and areas of expertise this afternoon. So with that, we have ample amount of time for questions. And since there's almost 50 of us, what we'd encourage you to do is type your question in the chat window, and then we can work our way through those and see what we can help with.
I can kind of start by answering one of the questions that you had sent to me ahead of time, if that would be useful to start the discussion. I can paste it in here. I think I've pasted the whole thing, yes. So this is what someone asked for their thesis. They're writing about a score that has not yet been published, but is already being performed commercially. And they were able to obtain a copy of the score from the composer. And if they want to use musical examples in the thesis, what procedures do they need to follow? And I actually think John's advice is fantastic advice. I don't think the best way to go about intellectual property is, what do I have to do? But what would I want someone to do if they were using my work? And if I were a composer, I would love if you were writing a thesis about something that I composed, and I would want you to have musical examples, but you should ask permission, right? You should ask permission, you should cite it. There are guidelines in the Chicago Manual of Style. There's a citation format for citing something that is unpublished that you received through personal correspondence, et cetera. And so I think the best thing to do in that case is to ask permission and to make sure that you're citing things rigorously.
Thanks, and I think that also speaks to the need to address issues of permissions as early as possible, so that when you're asking yourself, well, why not seek permission? The answer isn't, well, I'm in a hurry. So
right, and they can take quite a long time. Especially, I've had the most difficult time I've had is actually with art houses, because sometimes you'll have works of art that have now been acquired by these kind of big companies that are based in New York City or Paris, and they take a very long time to get back to you. So,
in general, though, I find that companies are quite pleased when someone actually seeks permission.
Very much so. Yes.
They do like to encourage that. So looks like we've gotten some questions in addition.
But if I could hop in for a bit on asking for permissions, I mean, I agree with what the other panelists have said, and I'm generally sympathetic. Where this gets tricky is when you have someone who's uncooperative, right? The James Joyce estate, for example, right? So if they don't want to grant permission, are you willing to not address that in your scholarship, right? Are you going to work around it? Do you really want that to, are you really going to like avoid commenting on something or criticizing something just because they didn't give permission? And so there may be times when you want to exercise a use, say under fair use, even when a permission isn't granted. So that's where these things can get tricky.
Yeah, and that's why I think it's important to just address that that's the case. I think like the appropriate thing to do is say, I made a good faith effort, and use what you need to use if it's for the sake of scholarly discourse, certainly.
I'll address Jean's question about teaching online. The workaround was to only use legal audio, library streaming audio, other audio that's legally available on the web, and to separate the annotations, the timed observations, the listening guide type of things, they're in a text file on Canvas. So students, and they could be using a video that I made that puts it all together like what you would find in the textbooks accompanying materials. But since that's illegal or too expensive, They just have to follow along with the timed listening guide and connect the annotations to the audio on their own. So kept it strictly legal.
Cool. And then another question from Kristen Wolski is for Rebecca. What was people's reaction to the abolishment of privilege? Because that was probably not popular among the people holding the privilege.
Well, actually, I mean, it was, there was this night a few weeks after the fall of the Bastille where people who were in the National Assembly were kind of seized by a patriotic spirit. And it was people who had these privileges who started standing up and renouncing them one by one. So, you know, one person stood up and said, everyone can hunt on my lands now. I'm gonna let people have access to that. And I'm gonna let people have access to my mill. And I'm gonna let people, you know, and they started renouncing their individual privileges as this kind of patriotic sentiment. And so by the end of the night, they realized that they had basically dismantled their entire socioeconomic and legal system. But most people in the country were negatively affected by that system. So overall, it was received quite well and patriotically.
Nice. That's the opposite of what I would have expected. Question from Adam Laspada, who's also helped plan this event. Just finished his doctorate, and his question touches on a little bit of what we talked about earlier with fair use, with our vanilla ice example. And so he said, you know, there's the assumption that there's a percentage involved in fair use, and then the issue of what if the item in question is really small, like a newspaper advertisement. Noting in his dissertation, he reproduced two newspaper advertisements, and so then you get into the, you know, paraphrasing the question, the compound nature of these items that, again, they were like our loot tablature example. They're, you know, solidly public domain in and of themselves, but provided by a paywalled service. And, you know, what the process is of being able, you know, to use those with a clear conscience and without fear of repercussions.
That might be something that Kevin can answer much better. I'd probably call him.
Well, there can be layers of copyright. You could have a copyright in an individual advertisement, and then a copyright for the newspaper as a whole, the sort of arrangement. And then there's a separate question of whether a database like ProQuest has any particular rights here, the company behind it. You know, we need to get into a bunch of specifics here to determine whether the newspaper itself is really still protected by copyright in the US. You know, if it didn't have a copyright notice on it up to a certain date, then it's no longer protected. So we don't have enough details here. In general, though, if there is an exact facsimile reproduction in a database like ProQuest or something, in fact, there is no copyright for the pure facsimile. However, databases like ProQuest or whatever, really most commercial websites have terms of use on them that govern what you can do. And so this is a sort of contract between you and that company or publisher, and it may in fact restrict what you can do. So they may have reproductions of public domain works, but then in their terms of use, they say you can't redistribute them. And so you're sort of still stuck there. And it's a question of contract law, actually, not copyright law. But, you know, really, if people have questions about these things, I do encourage you to contact us. You know, copyright@unt.edu goes to Yvonne and me. When there are complicated music questions, we bring in Maristella. We sometimes consult with others at other institutions as well to try to point you in the right direction on these things. You know, there can be, we often have to kind of go through a little back and forth to get all the facts on a particular situation to know what we're talking about.
And that's definitely one key takeaway from today, is that you'll if you could say you'll never copyright alone. There, you know, as you're working on your research, publications, and other projects, there are resources within your institution If you're not affiliated with an institution, you're still welcome to consult. And so there are ways to get an answer, and if you are doing a dissertation or something, to find out the risk tolerance and local guidance so that you can proceed with confidence. So another question we got very, very much related to the current situation from Brad Beckman is that this current semester in group piano classes, the semester ended with 6 weeks remaining. They've pulled the missing material into the next semester as much as possible. The problem is the textbook, it's a new textbook for the next course. So do the students need to be burdened with purchasing the previous semester's textbook, or can he provide material from a book that students previously purchased?
Yeah. So first of all, there is no clear-cut answer on this, as is the case with almost anything involving fair use. I think it sounds like this is a sort of sequence of courses, and it sounds like many, if not all, the students will be in the second course. And so my first thought is, well, don't they still have the book? But maybe this course, it's not so strict, and so there will be students in the second course who weren't in the first, and now are just going to happen to get a few weeks worth of material that they wouldn't have covered before. So I think that's the situation here. Our students sell back their books. That's true. And so they may not have known this would be coming, right? It's commonly accepted that a fair use would be reproducing a portion of a work for use in a classroom, such as an individual chapter of a book, when that's sort of the most relevant portion here. And when this is a kind of last minute change, this would weigh more so in favor of fair use, as opposed to it being premeditated and there's time to make the arrangements here. But this is a difficult kind of thing. There's no clear answer. I can't really give a blanket statement on this one.
From Susanna, one for Kevin.
Yeah, that's an interesting one. So it's about promotional materials like press kits that are distributed with the intention that they'll be further distributed. So you receive some sort of promotional material. What can you do with it? So first of all, when it's physical objects, under US copyright law, you do always have the right to sell those physical objects, give them to someone else, whatever. I mean, in a sense, you would look at me and say, well, why wouldn't I? Of course I go sell used books and all of that. But I do want to be clear that that is explicitly allowed under copyright law, right? The original copyright owner can't prevent you from doing that. With digital things, not so clear that you can do something like turn around and resell an ebook, for example. So if you get some sort of kit, then the question comes down to, did this kit have some sort of terms attached to it, right? In order to open this kit, did it say something like, you promise you won't give this to other people? Or where there was some limitation on it? But here, I think Susanna's actually talking about something different, which is you receive this kind of demo, and the assumption in the music community is that you are in fact going to make multiple copies of it, right? You are going to make copies and redistribute it here. And so that would be this sort of implied license, an implied contract here, where it's understood that you're supposed to do that. Does that carry over time? Right, intended for the press. But, for the press, I mean, if you're sending them to newspapers for the music critics to review, they're not actually going to reproduce them. They're just going to listen to them and write a review. But are you really going to redistribute? And if there's a sort of clear assumption in the community that that's what you're supposed to do, then you probably are safe redistributing, because the rights holder is not going to come after you. They expected you to do that. Now, if the library 30 years later inherits one of these demo copies, does that kind of implied license continue on to the library? That's tricky, not so clear really at that point. We're past that initial period of promotion. It's not clear that by making demo copies, the rights holder wanted to allow anyone to keep redistributing them forever. So not really very clear.
Other questions? And you'll notice the first answer to so many of these questions is that depends. It's a lot of times so much depends on the particulars of a question to see which element of the law is most applicable to a given situation. And again, it came up a couple minutes ago, the idea of licensing and contracts, and then it is worth reminder there that if you enter into a contract like that, or for instance, a Creative Commons license, then that agreement takes precedence over what may be in the letter of the law, because the contractual obligation supersedes that. So that's also something to be mindful of, especially in looking after your own rights and creative works that you might produce.
Another question that we had ahead of time that I'll put in the chat, and that maybe, again, Kevin might be better positioned to answer this than I am, but why did my advisor tell me I couldn't include an entire score in my thesis, even though I cited the source? The issue there is really that would just compete with the publisher's actual score, right? Because you would be providing that score for free, presumably. I know maybe your thesis would be behind a paywall, but I think the UNT theses are available right on our library site, right? So it would essentially compete with the original score in the marketplace.
Right. By longstanding policy at UNT and at many other institutions, our theses and dissertations are made available free to access online. You have to get a special exception to that if that's not going to be the case. So, right, if you're reproducing a work in its entirety as part of your dissertation, you're potentially impacting the rights of the right holder to commercially exploit that, right? To make money on their own by selling copies. But we do need to keep in mind that there is a distinction between properly citing sources in your scholarship and whether you need permission to reproduce something. These are two slightly different things here, right? I mean, citing sources is about giving credit, and you cite your sources not just when reproducing works in part or in whole, but also just for ideas, right? So you cite ideas even when you don't quote or don't reproduce any portion of the work. And it's just about sort of scholarly authority and giving a record of your ideas and relying on, showing that you have evidence for your arguments here. But this is slightly different from whether something's a copyright violation or not, right? So reproducing a work in whole, but citing the source, well, great, cite the source. You are not plagiarizing, but it may still be a copyright violation.
Excellent. We have two more questions. We'll try to fit them both in before the hour. First, again, from Kristen, what kind of permissions do you need to post a performance on YouTube of a composition that is under copyright, and how do you obtain those permissions? Yeah,
I mean, so a lot of these questions depend on what is our starting point here. Is this an unpublished score? Is this a published score? Or has this work been already performed and recorded, and now you're essentially covering? Because these are kind of three different situations that have slightly different implications in terms of how you go about things here. So it's hard to give a broad blanket answer here, and even who you're going to be then contacting. Are you finding the original rights holder, or are you going through one of the PROs or some other intermediary here? So the situation does kind of vary.
Yeah, I would start there with any guidance that YouTube itself may have.
Yeah, they offer, I believe, some sort of high-level introductory things there. I haven't looked at the specifics for music, and so they may, in fact, say a bit more about this.
True, and then we have time for one last question from Emma about what about a manuscript that you hold in your collections, but there is a published version available? Can you scan the manuscript and place it on a website?
Oh, yes, that's a great question. And it depends on whether that work was originally created long enough ago that it is now in the public domain, right? So if this is a manuscript from the 19th century, but there is a more recent published edition, then you could, in fact, come into the library, take a photograph of that manuscript and reproduce that photograph of the manuscript, because you're only implicating this manuscript here, not the more recent publication with any additional scholarly editorial decisions or potentially copyrightable material added by a subsequent publisher. So assuming the UNT Libraries allows you to do that by policy, which I think we generally do, then you're fine. Certainly if you're using some other library that has restrictions on what you can photograph in there, that you have to agree to when you walk in the building, I don't know, Vatican Library or somebody, that says you can't come in and photograph things. Well, that's a different set of situations here. And it's, again, essentially a contract between you and that library that could supersede copyright law.
All right, well, we're just about on the hour, so I think with that, wanted to give one more round of thanks to our presenters today and all of the people behind the scenes who have helped make this happen in planning. And thanks to all of you who have attended today. This is going to be the first in a series, and we hope this was useful, and we'll hope to see you again sometime.